Ladies and gentlemen, I welcome all to my channel. Today we will discuss an interesting judgment passed by Karnataka High Court in former Chief Minister Jayalalitha's property return case. So in this case, the legal heirs of former Chief Minister Jayalalithaa filed a petition to return golden items, silver items, which were all seized from the former Chief Minister Jayalalithaa. Let us see the judgment in detail. Before going to the contents of the judgment, let us see what is the background. So regarding the case, criminal case, a criminal case was filed as against the former Chief Minister and against various other person for assets disappropriate case. The properties they have the allegation they have acquired their income and their assets they have acquired are disappropriate, and so they have acquired several properties like what some criminal cases were filed, and the court has the trial court has convicted former Chief Minister Jayalalithaa and also the other accused. And as against the judgment, an appeal was filed before the High Court of Karnataka. And interestingly, the High Court of Karnataka allowed their appeal, and as per the High Court judgment, they were acquitted. Jayalalithaa and other accused were acquitted, so they were the trial court order was set aside. As against the High Court judgment, an appeal was filed to the Supreme Court. When the case was pending in the Supreme Court, former Chief Minister Jayalalithaa expired, and so the Supreme Court came to a conclusion that it's not worth to continue that appeal as against the dead person, and so the court held that the case against A1 J. Jayalalithaa is abated. Like what the court abated means it came to an end. Like what the court has Supreme Court has Appeals Court has confirmed, passed an order. So as far as A1 Jayalalithaa is concerned, though trial court passed a conviction order, that conviction order was set aside by the High Court of Karnataka, and subsequently when the appeal was pending in the Supreme Court, the court has also that the case as against A1 was abated. So therefore there is no criminal accusation as against the A1, and on the ground they have asked for return of the property. That was the petition filed by the legal heirs of the Jayalalithaa. But the case was actually the petition was filed under section 452 of Criminal Procedure Code before the trial court. So the 452 speaks about the order for disposal of property at the conclusion of the trial. So since this trial was concluded, they have filed a petition to return the property on the ground that there was no conviction order as against A1 Jayalalithaa, and that conviction order was set aside by the High Court. So there is even Supreme Court does not pass any conviction order, so that the order of the High Court is final as against A1, and on that ground they have claimed filed the petition and claimed for the return of the property. See, the trial court when the application was filed under 452, the trial court dismissed the petition, and as against that they went to they filed a petition before the High Court, and the High Court has passed this judgment. So as far as this is the argument raised by the petitioner, and it was objected by the government side, and finally the court has rejected their application and dismissed the application, and observed that as far as the judgment of the Supreme Court is concerned, in para 536, the Supreme Court has though stated that the case against A1 is abated only on the ground that she was no more. Since the A1 died, the case against A1 is abated. So No other findings were made as against any findings as against A1 is concerned. Further, in 542, para number 542, the Supreme Court has clarified that the trial court order is restored in full, including consequential direction. That was the observation made by the Supreme Court in para 542 of the Supreme Court judgment. So the High Court referred this provision, this findings, and stated that since the Supreme Court has clearly stated that the order of the conviction order of the trial court is restored in full, including consequential direction. So that means that the order of confiscation order passed by the trial court is final, and it was fully upheld by the Supreme Court. Like what? So there is no question, there is no further clarification, findings required, since the Supreme Court order is very clear, in which it has clearly stated that the order of the trial court is fully restored and consequential direction is including the final consequential direction. So therefore, which means that the confiscation order as against the assets of the Jayalalithaa A1 is also final, and so since the order, the movable parties are already confiscated, they are not entitled to get back the legal heirs of the Jayalalithaa is not entitled to get back these confiscated goods. So there is a difference between. I just want to clarify one thing. There is a difference between seizure, confiscation, or attachment and confiscation. So when the criminal case is registered in the police station, then the police will go and seize the property. That is when they will take over the possession of the property. That is called seizure. Subsequently, when the matter is pending, the court may also order for attachment. That is also done before the conviction of trial. Final order is passed. Once the final order is passed, the court may order for confiscation. Confiscation means they are taking once the order of confiscation is passed, this property which is confiscated will become the property of the government. So as far as this case is concerned, confiscation order is passed by the trial court itself, and that order was already upheld by the Supreme Court, which clearly stated that the trial court order is restored in full, including consequential direction, which means that the confiscation order is also upheld by the apex court, and so they are not entitled to get back the property, like what this trial court judges, this High Court judges observed in its judgment. So one of the interesting thing is, before when the matter is when the argument is over, the Justice V. Sirisa Nanda has suggested the counsel for the petitioner to form a trust and to do some welfare activities to the poor out of the assets of the assets left by the Jayalalithaa, former Chief Minister Jayalalithaa. Yes, it is reported in the live law commentary, which says that the judge has told in the open court that rightly or wrongly you are declared as by the court as a legal heirs, and you have got this property, and now you got an opportunity to do good things to the public, and you can get the gift of God by doing forming a trust and giving doing some charity works to the poor, by which you will also get the God's blessings. In addition to that, what is called the soul of the late Jayalalithaa will also be get blessings. அந்த ஆன்மா சாந்தி அடையும் அப்படின்னு சொல்லுவாங்க இல்லையா, அது மாதிரி the ஆன்மா of that is the former chief minister will also get fulfilled when you do when you do a charity to the poor, like what the judges orally suggested. It only shows the broad-minded, very clear-cut thoughts of the what do you say, the conscience of the judge. So in my opinion also, when Chief Minister Jayalalithaa was in power, these legal heirs, especially now who claimed their who got all the properties, who are declared as legal heirs, were to my knowledge that they did not live with that Chief Minister during her lifetime. So during her lifetime, the Chief Minister lived separately, and she always thinks about the public, especially the poor and school children. When you see the history, when you see the things, you will learn she has done a lot to the poor, especially to the school children. They have donated cycle, laptop, and gave a lot of scholarship to the students. And she has also opened Amma Unavagam as mother's canteen, like that. They have opened Amma Unavagam and gave free food to the public. So besides that, she has also before she came to the power, the alcohol shops are run by politicians. Then they got the money. But when she came to the power, she has started a trust mark, and all the trust marks are run by the government, and all benefits, profits are acquired by the government, and out of that, she has done a lot of welfare activities, especially to school children and to the Amma Unavagam and to the Amma Unavagam. So that was the thought of the former Chief Minister, and she was also called as Amma. So that means she has, by conscience, she has adopted the Tamil people as her, all the Tamil people as her children, and all the Tamil people also called her as Amma. So they have also consciously adopted Jayalalithaa as their mother, which means that the real legal heirs, the adopted legal heirs, that all Tamil peoples are the adopted legal heirs of the Jayalalithaa, and she also liked that she liked the practice of calling her Amma by all the Tamil peoples. So when she lived like a mother, and so to my conscience, the properties left by the Jayalalithaa has to go to the poor and the poor, or especially to Tamil peoples. So that if that is done as expressed by our Justice V. Sirisa Ananda, the Anma of Jayalalithaa will get fulfilled, and it will also be the it will also be a good thing, good practice as per the conscience of the people. So I hope this video is, I have clearly explained the backgrounds and the facts and circumstances of this case. I will come again with another topic. Until then, goodbye. It's Razia Kali.